Good evening, doctors, lawyers, colleagues, and educators. It's great to meet you all. My name is Kim Lee, Director of Partnership Development at the University of Law. There are often diverse medical legal incidences leading to complaints and claims by patients against healthcare professionals, clinics, hospitals, and these can never be avoided totally. But it can be better managed at an earlier stage to prevent escalation to the courts and to the medical council. The University of Law are delighted to bring together an expert panel who I will introduce in a moment and will be our speakers for today. The panel of speakers will be sharing their experiences and discuss the different ways of managing complaints, claims, and highlight how ongoing open communication are essential. The University of Law has a presence here in Hong Kong. And on that note, I'd like to introduce you to Sabas Michael, the Program Director and Senior Lecturer at the University of Law Hong Kong campus. Please do feel free to contact either of us if you have any questions. Our contact details can be found on the slide, and I'll be keeping an eye on questions which will be raised during this talk. We have indeed allowed time at the end of the talk for these questions. So please ask your questions within the Q&A box and we will address them at the end. To give you some background information on the University of Law, I will not read through our full history, as you can see on this slide, but we are one of the UK largest and longest established specialist providers of legal education. Many of you may have heard of us as the College of Law, which we were known as until 2012. We were then rebranded as the University of Law. And in fact, Mr. TKU, one of the speakers today, is a University of Law alumnus from our Chester campus and also a mentor of our students. Whilst we focus providing courses on qualifying lawyers and barristers, we now have many courses which focus on upskilling professionals in other fields. As you can see from the slide, we have plenty of postgraduate programs, including an LLM in medical law and ethics and ADR. The Masters of Laws, Medical Law and Ethics is a postgraduate degree designed to enhance your academic knowledge, particularly focusing on specific areas of interest. In this course, focusing on medical law and ethics, they are integral to the individual's development. Ideally, if you have a qualification in medicine or ambitious in work in medical liability. These are available online in Hong Kong, but also online on a full-time or part-time basis. I've just included some links here on this slide. And if you want to find out more about these programs or the Hong Kong campus as well, the email address will be there for us for you to contact. Now, without further ado, this is our rundown today. We will be focusing on a very informal discussion, which will have Ms. Tracy Zhang, Mr. TKU, and Dr. Rob Hendry. They'll be focusing on the complaints, claims, and communication with these areas of focus, looking at how you can improve effective communication and active listening amongst specific ADR and mediation focus, including the Apology Ordinance. Towards the end, we'll have Q&A, and we'll have a final conclusion, and we should end on the hour at 8 o'clock. Ms. Tracy Zhang is a medical legal solicitor, a mediator, and consultant for over 15 years. Her experience in advising healthcare clients in dispute resolution and litigation, she provides independent legal and alternative dispute resolution advice and solutions to medical legal disputes. She takes a holistic approach in risk management and professional training. Currently, she's practicing independently and launched the T-Med Corporation. Previously, she was a partner at the international law firm Kennedy's. In addition to that, she advises on complaints management, complex high-value catastrophic medical legal negligence claim, and defend healthcare professionals in disciplinary investigation and regulatory proceedings. She has a passion in ADR and Apology Ordinance. Our next speaker, Mr. Ting Kwok Yiu, is a leading mediator in with 30 years of legal experience in Hong Kong, he holds a Master of Arts in Arbitration and Dispute Resolution, Arbitration Mediation at City University. He also studied at University of Law, Chester campus, an active alumnus of the University of Law. TK assisted and advised the Department of Justice of Hong Kong on the enactment of the apology legislation and the Hong Kong Apology Ordinance, which came in effect in December 2017. TK continues to serve as a chairman on the Special Committee of Valuation Mediation and the committee advising the Secretary for Justice on issues related to the use of evaluative mediation in Hong Kong. He's the HKMAAL accredited mediator, family mediator supervisor, and is internationally accredited as a panel mediator in Singapore's International Mediation Center, as well as WTC Macau Mediation Center. And finally, Dr. Rob Hendry is the head of medical protection, medical director. He studied at the Dundee University studying medicine before spending 12 years as a partner as an urban teaching practice. He developed interest in medical law and completed his MPhil in law and ethics in medicine at Glasgow University in 1992. This led to consultancy work for the Medical Protection Society and part-time teaching at Dundee University. Since obtaining his MBA at Strathclyde University Graduate Business School in 2001, he continued to develop his business interests. He's also a foundation fellow of the Faculty of Forensic and Legal Medicine, which he continues to teach on, and holds honorary positions at several universities and has served as several government working parties considering dispute resolution and management. So with that, I'll pass over to Tracy, who will kick us off.
Thank you, Kim, for that introduction. Good evening to those in Hong Kong. Good morning to those further afield, maybe in UK, but I hope you're having a good evening, you're staying fit and healthy. I'd like to begin with really setting the scene for our discussion today, sharing some of my experiences, and also to really kick off, I'd like to express my heartfelt thanks and appreciation for the healthcare workers, the professions, all of you present today, taking your precious time out to attend this webinar. We hope it will provide a useful overview of relevant laws, developments, and also provide some practical advice. Know that we're available online this day, and your efforts in the public health situation now is appreciated. Facing challenges, healthcare professionals are certainly facing unprecedented challenges globally, in particular in Hong Kong locally. I've had a number of concerns, issues raised by my learned friends, contacts. Hope this will provide good overview, some comfort, additional knowledge to you. So concerns of healthcare professional providers, taking into account the interests and the needs of patients, the public at this moment, ever-changing policies and developments. For students also are interested in this area, it's also appropriate, and I'll try to keep it in simple terms for everyone to really understand. So just to start with, now there's a rise in an upward trend in the number of complaints against healthcare professionals. This is not just in Hong Kong, but worldwide. Profession is put at highly respected and they're essential, in particular in fighting this pandemic. But why? I want to see why really patients complain, why they make formal claims for compensation and medical negligence or other sorts of actions. I'd like to highlight really through my fellow panel speakers and how we can enhance the communication, the understanding involved. Communication involves risk management, how to manage every day. There are risks in providing healthcare services, even though doctors, healthcare workers try their very best with the resources available, take into account public health, their own health and concerns of their own, nurses, assistants, those in public service, private medical services. So this way, how can we manage those risks better? I like to use short forms with lots of C's and P's here. CPs, complaints, claims, communication. Now, just to illustrate this rising number of complaints, information published by the Medical Council in December 2021, looking at the data, the number of complaints received by the Medical Council in 2020 increased from the previous year, 3,287, up to 3,356. Now, of those, large percentage is for disregard of professional responsibility to patients. What do they consist of if we read between the lines? They relate to failure, unsatisfactory result of treatment, surgery, timely diagnosis of illness, disagreement with doctor's medical opinion. They also look at unnecessary or inappropriate alleged treatment or surgery, inappropriate prescription of drugs. What I'd like to highlight is also they relate to doctors' alleged unprofessional attitude, doctor-patient communications, and then failure to relate to alleged proper medical advice or explanation. Kim, could you turn to the next slide, please? The point to highlight there is that many of the cases I've handled, and these will continue to arise, in particular with the pressures on healthcare providers in terms, and also at times when there are resources and lots of changes going on. How do we deal with it? How can we manage patients better? How can the original trust or establishment of a good relationship between patients and doctors, how can that be maintained? What happens when this breaks down through miscommunication? There might be bad feelings, unexpected outcomes of advice or treatment given. In the many years of my practice in the medical legal area, often mismatched and miscommunication results in complaints. The proper handling of that complaint at an early stage really does set the scene for possible things that could happen. The key is really to prevent the escalation of complaints to form a claim in terms of a formal claim where solicitors are involved, medical expert evidence is called for, and proceedings are started in the courts, or a formal claim is made to the relevant regulatory body, whether that's a medical council, dental council, nursing council, physiotherapy board. Across the board, allied healthcare workers also faced with increasing pressures and under greater scrutiny. That's the reality. But how do we better manage them? Prevention is better than cure, doctors very much say. What we would try to do through this discussion and through some of the sharing in the brief time I had is how to prevent that escalation to litigation and disciplinary action proceedings. We know the stress and impact and the long process that the medical profession and healthcare providers and workers face in facing that, in reporting that, notifying the indemnity provider, ensuring that they are covered by that indemnity, by that insurance, ensuring that they get timely professional advice and evidence as needed from, say, medical experts to consider how to manage these claims and cases. The communications, not just before in prevention, but things happen, it's reality. Communication after is even more crucial, after an adverse incident, when there has been dissatisfaction by the patient against the hospital, the individual doctors, the nurses involved. Communication after is key, and I've set out here very briefly, what that involves. Very often we think about healthcare professionals and then the dispute between them and the patient, the family, due to an expected, say, outcome, complication, surgery that they didn't expect. But the internal communications that I worked in the public health sector advising them, even more important when things go wrong, how they communicated, how is the complaint dealt with? Initially, it may be by a clinical assistant. How's that conveyed to the doctors or other healthcare workers involved? The need for timely discussion to meet together, come to a consensus how to deal with it. The need really to inform your indemnity advisors. Ensure, check your indemnity. What are you covered for? As these are sort of complaints and claims, or the advice I've given to clients, do find out, have this to hand. If not, after this webinar, check your indemnity provider, when you should notify, who you should notify. Or I've worked with many indemnity providers in providing medical legal advice. There are opportunities, with medical protection in Hong Kong, avenues of getting help, professional help, notifying the HKMA, Medical Association, contacting the indemnity provider directly, contacting panel solicitors, get that advice firsthand reported. And most importantly, more C's there, the need for coordination, consistency, and continuing communication between all these parties to better manage the claims and complaints to prevent escalation. Kim, can I have the next slide, please? So after all that, investigations, find out what happened, retrieve the relevant medical records, the documentation, what actually happened. Get the professional advice, notify those claims. Early discussion can also means that not every complaint or claim will turn into a formal court case or a complaint to the medical, dental council, etc. There's options. The advice that I've given and the pointers is we want to highlight in this webinar is that there are alternative dispute resolution options. ADR equals options. One of these, and the main purpose is to resolve the disputes. Get the parties together in the appropriate forum, whether that's through mediation a process, using an unbiased, neutral third party, a trained mediator. Structure process involving one or more meetings, and that could be in person, it could be online. There are suitable platforms for that. There's the eBram, specifically the platform launched in Hong Kong with government funding, allowing secure access of the parties by agreement, conduct the mediation online. Everything from appointing the suitable mediator must be by agreement by two parties, but then to actually go through this structured process, be able to talk to each other, the mediator's skill, whether there's been breakdown communication, distrust, anger, in appropriate forum with a trained mediator, parties can come together in confidence, sign the relevant undertakings to keep all mediation communications confidential, supported by the mediation provisions under the Mediation Ordinance. Try to identify, narrow down at least the issues in dispute, generate options, that's the key word. Options. It's not just litigation and court case years down the line, lots of stress, long process. There's other options. First thing is find out, sometimes often in this process, the patients or family, there might be misunderstanding. They might want to find out more. Appropriate forum with the present legal advisors, indemnity provider if necessary. Get the parties talking again. Try to come to some settlement. Conciliation. Another side of form where appropriate ongoing communication can reconcile the disputes, usually at an earlier stage. MedOrb I've just flagged here, and a future development may be possible under the EBRAM online platform. Communication is aided to do mediation arbitrations online. Arbitration goes further than mediation, whereas arbitrator can actually adjudicate. They can actually listen, similar to sort of a trial judge in a case, skilled in that particular area. At present in Hong Kong, we do not have arbitrators in the medical healthcare sector to resolve disputes, usually in the construction industry, architects and things like that. But maybe in future, it's something to flag up, bring some finality, have some agreement, start with negotiation, attempt mediation. If that's not possible, at least narrow down the issues, get the parties talking together, go on to maybe arbitration rather than waiting further down the line. It's a possible development. Don't know how that's, that will come about, but certainly is a thought, food for thought there. Candor will look at, Dr. Rob Hendry will discuss more about the need for openness, honesty, and also use of apologies, because very often, sometimes in these complaints and claims, it's trying to get to what my role and experience has told me, that there's lots of it's with human nature. Both doctors and patients and their families will get stressed under these situations where there has been a dispute, adverse medical legal incident. There's a need for that, for the communication, the openness, the disclosure, the need for healthcare workers and also patients for further communication, elaboration on what went wrong, find out, and also focus on what next, rather than disputes, not just about financial compensation. Sometimes the thoughts of the patients is what happens next, something's happened, the immediate care has to be dealt with. Apologies often requested. The Apologies Ordinance for Hong Kong, the first Asian jurisdiction to enact apology legislation to protect and promote the making of apologies with legal protection. Now, this ordinance came into effect the 1st of December 2017. It's an area I'm very interested in, and having been a litigator lawyer for over 15 years, the need and the recognition for the protection for apology makers who want to do that, whether that's a healthcare worker faced with a potential complaint, disciplinary body, or future litigation, where the makers apology in appropriate circumstances with the relevant advice, take that on board to promote that, and the overall effect and purpose of the apology ordinance is to promote that, to try to resolve and settle disputes. When things do go wrong, and they can do, apologies may be appropriate. And even then, expressions of regret, showing the sympathy, the humane side of practicing medicine, backed with the protection of the law, so that even in the form of what we call full apology, would not be implied or expressly taken as evidence of admitting fault or liability in proceedings as defined under the apology legislation, such as civil litigation, medical negligence claims, or even disciplinary proceedings before the relevant bodies. Just like to end up with a point about the need for continual professional development. Healthcare professionals hold high esteem, but things are changing all the time, the legal or professionals. And really the emphasis really, especially in such times, the need for further public health education. Maybe the extra time and explanation needed, how we can do that. To be efficient as also take care of the number of patients. Understanding application of the relevant laws, regulations and policy, keeping up to date. The relevant protocols to draw on, be familiar with the professional codes of professional conduct which govern them. I'd like to highlight new publication and clarification much welcomed, published today by the Medical Council of Hong Kong about telemedicine, ensuring that doctor-patient relationship, how we can do a very good point made and clarification on that. We'll discuss more of them in the panel discussion. Main thing is clarifies and give doctors more options to better treat and also cater to the growing needs of patients, where previously face-to-face in-person consultations prior were advisable really prior to a teleconsultation, whether that's by phone, by video conference, etc. Now, they are not mandatory for a first-time patient, but still the reminders to take appropriate steps to ascertain the identity of patients, providing the relevant treatment options available to them, and the need for documentation. As I always end in many of my seminars, keep that recording for your future protection, and also to ensure any relevant handover to other healthcare workers. So I'd like to just end on that point and pass over back to Kim. Just details of some of my background research, and feel free to contact me to elaborate on any of the points. Back to you, Kim, and TK to speak next. Thank you very much.
I think we'll move on to TK immediately, so that TK could impart some of his wisdom onto us. As I mentioned earlier, TK has a lot of experience in mediation and ADR. The floor over to you, TK.
Thank you, Kim, and thank you, Tracy. First of all, I would like to thank the University of Law for having me here this evening. And in case you are in a different time zone, good morning, good afternoon. First, start with an apology. I haven't done much preparation because for this week is a busy week, 3 mediations done, and for today is a bit of crisis management of my office. So my apology if you feel that I haven't done sufficient preparation, but Hong Kong is like crisis every day, right? So to start with, for those who are doctors or lawyers, you must be familiar with something that I'm going to read. So I'm going to read something in order to refresh your memory, and that is not something very new. And I'm going to tell you what I'm going to say, right? You can see from the chat box. That's not very new. That's 1994, an article published in the Lancet. The abstract of that article is about to examine the reasons patients and their family relatives, why they take legal action against the doctors. So since one of the topics for today is about claims, so let us go back and revisit this subject, right? And it seems to me that it still holds 100% of truth, right? According to the abstract of the article, it says like this: over 70% of the respondents were seriously affected by the incidents that gave rise to litigation with long-term effects on work, social life, and family relationships. Intense emotions, let me repeat, intense emotions were aroused and continue to be felt for a long time. The decision to take legal action was determined not only by the original injury, but also the insensitive handling and poor communication. Communication, that's one of the topics, after the original incident. Where explanations were given, less than 15% were considered satisfactory. 4 main themes emerged from the analysis of reasons for litigation: concern with standard of care, both patients and relatives, to prevent similar incidents in the future, the need for an explanation to know what had happened, why, compensation for the actual loss, pain and suffering, or to provide care in the future for an injured person, and accountability. I believe that the staff or organization shall have to account for their actions. Patients taking legal action wanted greater honesty and appreciation of the severity of the trauma they have suffered, and assurances that lessons have been learned from their experiences. A no-fault compensation system, however well-intended, would not address all patients' concerns. If litigation is viewed solely as a legal and financial problem, many fundamental issues will not be addressed or resolved. So this is the beginning of my sharing. Right. So after reading out the abstract of that learned article in the Lancet, let us deal with emotions, communications, right? So from my experience, from my humble experience, communication is one of the biggest issues. You can, doctors, lawyers, they may have good grades at the college, at university, but then when we talk about communication, let us go back to the fundamental. There are some fundamental problems of communication. If you want to have some sort of reading, I would say go back to the old book of Getting to Yes by the three writers, Roger Fisher, William Ury, and Bruce Patton. Page 33. I'm not going to read that out, but let me just explain to you. For communication, one of the biggest problems is that when two persons are talking, they may not be communicating because their messages are not directed to the other party. They are looking for the support of the judge. They may be looking for the support of the voters. They may be looking for the support of the spectators. So this kind of communication or discussion or talk it is not going to be conducive to solving the problem. Instead, it could be very adversarial because they will wait for the voters, spectators, or the judge to side with them, side with A or side with B. Another issue of communication today is that we communicate not for the purpose of the other party's understanding. I tell you a story, real life story, that had happened to me when I was doing ultrasound as a patient at one of the prominent hospitals in Hong Kong. The young lawyer, I beg your pardon, the young doctor who was doing the ultrasound for me. So at the same time, he's the guy. And at the same time, a young lady was standing next to him. Somehow, she was flirting to him while he was doing the ultrasound for me. So because at that time, I wore shorts, sandals, looking like an ordinary uncle in the street. So she spoke English to the guy doctor, to the male doctor. And she started to ask him to go out, going to cinema, that sort of thing. So if you put yourself into the shoes of the patient, just start with, I'm the uncle, without knowing, without any knowledge of English. You know, two persons speaking a different language in Hong Kong, not known by me, right? Is that all right? But it seems to me that today, a lot of doctors, when they talk to each other in front of patients, they would not use the language to be understood by the patients, right? Of course, I'm not going to tell you the detail of the story. Basically, after 10 minutes, you know, I politely use my very Hong Kong English to tell the lady doctor that either she leave or I give a call to CC Look, right? So that's one thing. So my point is that when we do communication, are we or were we or did we? So what's the intention of the communication? Is to let the other party understand you, or is to show that you know something better than the others. Lawyers are the same, you know, taxation of costs, right? It could be said as assessment of legal expenses, but a lot of lawyers, even after a practice for 30 years, 20 years, they still could not find the right simple way of expressing themselves. So the third problem of communication is, that they are not careful. They are not careful about the choice of word. Say, for example, if you tell the parties, I'm the mediator, I'm here to work out a compromise for you guys, for the parties, party A and party B. The party may feel frustrated because they don't look for compromise. And if you tell them that I'm a mediator, I'm here to work out a compromise, right? Then they may not have the requisite confidence in the person. So normally we'll say that we're going to work out something which is acceptable to you. Sometimes I say win-win, but sometimes win-win is a little bit too much. I'll find a way which both parties could find that way acceptable. And the fourth problem of communication is the failure to listen, right? We don't listen to the others. We want to talk back. We want to give advice. And listening is one of the most difficult things that we have to learn. And if you are interested to know more about the power of listening, go to YouTube, key in William Ury, the power of listening, and then you will understand from him that one of the purposes of listening is to understand each other. And the more important thing is to connect with the parties, right? And also to get to yes. So when we deal with complaints, when we talk about communication, my sharing is that don't think of some sort of high-level skills which can assist you to persuade the parties or the person you are talking to. My humble experience is this: the best way to communicate is to listen carefully about the needs and concerns of that party behind the position. So communication, when we say communication, but I have learned this from a stand-up comedian called Vivat Mahbubani. He's a Hong Kong guy of Indian descent. He said to me that as a stand-up comedian, you know, people will not enjoy your show unless they like you as a person. So the best way to communicate, apart from listening, is how to connect with the parties. And how to connect with the party, because we don't have much time, I can flesh out the idea is empathy. Always think from the angle of the other party. By way of illustration, you can tell the public, the Hong Kong public, that now the situation is very bad. You know, the cases are too many. That's beyond our capacity. That's the reason why you have to go home, you have to wait, because that's beyond our capacity. But on the other hand, you could say something different. This is unprecedented. This is out of the expectation of everybody. We are the healthcare professionals. It is our mission to do the job in the best way for each one of you. I do have family members who have anxiety over COVID, right? We will do our best. There must be areas that we could have done it better. But since we are walking the journey together, give us some patience, give us some time, and let us walk the journey together, step by step, at a pace that we could give you the best service. Finally, talking about communication, one thing to avoid, I always tell my students, try not to say, I understand you, because we are not able to understand the other person. If you say you understand, I understand you, impliedly, you're telling the other party to shut up. Now I'm moving to another area of mediation. Tracy has helpfully talked about the Mediation Ordinance. The Mediation Ordinance has give some sort of guideline about what mediation is about. Long story short, mediation is assisted negotiation. That means the third party neutral is there to assist the parties to negotiate. So what he doesn't do, he does not adjudicate the dispute or any aspect of it. You can find the definition in Section 4 of the Mediation Ordinance. What he does is to assist the parties, he together with the parties, assisting the parties to identify the issues of the dispute, what the concerns are, and also he assists the parties to generate options, right? So issues and options, right? Daddy, I want to go to McDonald's. So you don't assume your boy, your daughter wants to go to McDonald's for the bun, for the hamburger. They may want to go there for the gadgets, for the Snoopy toys, right? So we have to identify the issues. You know what the concerns are, the needs are, and then generate options to address those needs and concerns. And also you assist them to communicate. So that means you need to know how to communicate. And as I said a moment ago, one of the difficult things in life is that we need to connect with parties within a short period of time. My sharing is listening. My sharing is empathy. Try to make the person not dislike you, if not to the extent of liking you. And then if there is a settlement, assist them to draft the settlement agreement. And this is not easy because once they're settled, you may not have time to do that. But once we have some training, we can do that. And I will use the next 5 minutes to talk a little bit about apology. Once again, the book by William Ury, Roger Fisher, and Bruce Patton, written in the early 1980s. Once again, page 33, I read out this short sentence. An apology may be one of the least costly and most rewarding investments you can make. We, as mediators, as conflict resolution persons, we understand and we will share that for dispute, at least there are 3 dimensions, right? One dimension is right or wrong. The other dimension would be emotions, right? And other dimension will be the power. Right or wrong, go to the judge. The lawyers will say that you will have a case. You will have a fair chance. But then, of course, the judge will be the person to make findings of fact, findings of law, right? So we can't just go to the judge every time. But when we resolve conflicts, we have to touch on the emotional dimensions. So how to deal with highly emotional people at the hospital, at the clinic, or in the mediation room. My way of doing things is I slow down. Firstly, I acknowledge high emotions. Number two is I slow down. I say that it sounds like what you are telling me is very important. I'm now going to give 100% attention to you. I'm going to use my long hand. I jot down what you are telling me. So in that case, I slow the speaker down. And also in the course of writing down, taking notes, I will use a lot of reframing. Reframing in the sense to make sure that I understand what he's telling me. But then by doing the summarizing, I will use the reframing skill. Reframing skill, just in case you are not aware of this term, I use one example. The Chinese always say this: failure is the cradle of success. So failure is failure. Why failure is cradle of success? So if you are willing to accumulate the failure experiences, work harder, don't give up, one day you will be successful. So failure is the cradle of success is one illustration of reframing. So when we deal with the highly emotional people, we use the reframing skills. And apology is another thing. Apology is to touch upon the emotion of the other party. I'm not going to read out the details of the apology legislation. Basically, the idea to have the apology legislation in Hong Kong is to encourage the people to use apology so as to de-escalate conflicts, even before litigation, even before arbitration, and before mediation. And that's the reason why the apology legislation that was, I think that came into effect on the first day of December of 2017. That part, that will make any insurance term saying that you can't apologize, you can't, that make those clauses void. And also it covers disciplinary proceedings in addition to civil proceedings. So apology is one of the things that you may use, right, to gauge the emotion of the other parties. So normally when a party says, I want the other party to apologize, as a mediator, I always start with, how's that important to you? Tell me more. And then to find out what is behind the request for apology. That may be a way to jack up the money claimed, or that is a genuine way to touch upon the emotions, right? Since time is running out, I also have to apologize to Rob. So I pass the time to Rob, and he will share his wonderful knowledge with us. Thank you, Rob, and thank you, Kim.
Thanks, TK, and good evening, everyone. It's a real pleasure to join you. I've had the honor of working with Kim and Tracy in the past. It's great to also link up with TK tonight. Really very, very interesting couple of talks there. And I suppose one thing that's come over loud and clear is the need for better communication, and indeed a change in culture to support that in medicine where things have gone wrong. So what I would like to do just fairly briefly, and before we open it up for discussion, is to pose the question that can changes in the law lead to changes in culture? And I suppose the starting point for all of this is that what we would like in an ideal world is better patient care, where things don't go wrong, patients aren't harmed, and there's no grounds for complaints or claims. But of course, that's not the world we see. And it's now over 20 years since the Institute of Medicine in America published their seminal report To Err Is Human. And at that time, there was a lot of emphasis put on the need to learn from adverse incidents and to improve patient care. Sadly, progress there has been very slow, and complaints, things continue to go wrong, patients complain. We see numbers of complaints going up to the Medical Council, increasing, as Tracy was mentioning. And a lot of that seems to turn on poor communication and an apparent lack of openness. So the question that has been faced by a lot of legislators around the world is whether introducing a duty of candor could improve things. As Tracy mentioned, we have in Hong Kong the Apologies Ordinance to try to make it easier for people to make apologies, to say sorry when things have gone wrong. But would an obligation, a legal duty that would require institutions to explain to patients what has happened when things go wrong, improve the situation? Such laws have been passed in some of the countries I work in, like England and Wales, Scotland. There's ideas to do this in Ireland. So what I thought I might do is just share some of my experience and reflections on that, particularly if legislators in Hong Kong were thinking of taking things further in this direction. So is a lack of candor, a lack of openness the problem? Well, one of the issues I see is that, as previous speakers have mentioned, when things go wrong, there's often a huge amount of emotion involved, not just with the patient or their family, but also for the doctor or the healthcare worker, who's going to be extremely upset, embarrassed, and distressed when things have gone wrong. And that can cloud the ability to make clear judgments and clear communication. Medical cases are often quite complicated, and it may not be very obvious at the start what the truth of the matter is, where something has happened and a patient has either come to harm or sensed that they've come to harm. And often you need to investigate things in some detail before there can be clarity. So I think it can be slightly naive to say that one can have full candor early on in the situation. It also requires skills to speak to families who may be upset, angry, and a lot of what TK was talking about, the complexity of the need to be able to empathize and communicate in a meaningful way with people isn't something that all of us have. And I think there is need for more training in the kind of skills that mediators have. And if there is to be any introduction of an obligation to be candid, it is really important that the institutions train people and have on tap, if you like, people with the skills that TK spoke about. Again, people are wanting not just to know what happened, but what happens next. And I think that is something that sometimes can be lost in this. And underpinning it, one of the big barriers I see to openness and candor is the fact that in Hong Kong, as in many other places, we still have a desire for an open inquisitorial approach when handling adverse incidents. But in the background, we have continue to have an adversarial and punitive system of disciplining doctors, holding doctors to account, whether it's internally or before the regulator, before the Medical Council, where doctors and other healthcare workers may be anxious about saying things that could be used in evidence against them. And I think that's an issue that needs to be reconciled, and I'd be very interested in TK's views on how you balance the ability to be open and honest, but not giving away one's rights to being able to defend oneself in a regulatory environment. So I think time will tell whether this legislation will impact better communication and better learning. Clearly, the ability to communicate well is key to it. And I think I'd like to pick up on one of the points TK made about the fact that generally, if people like you, they're much less likely to complain or complain about you if things go wrong. And there is some evidence that patients make a very early decision as to whether they like you or not in a consultation or in a clinical setting, and that getting that right can often be a good way of avoiding these complications if and when things sadly go wrong. So I think it would be useful now just to throw the meeting open to a bit of discussion and take any questions that are coming in, Kim. Thanks.
Thank you, Rob. Yes, I'll invite all our speakers to open up their mics. We do have quite a number of questions here. I'll go with the very first one, which was quite interesting. So the question goes, has telemedicine caused more medical complaints of late? And are there any specific issues? So yeah, Rob?
Yeah, that's an interesting one, because obviously there's been a huge growth in telemedicine and teleconsulting. I have to say, from MPS's experience, I haven't seen a great increase in complaints. Some patients don't like it, but we haven't seen many serious ones. And I suppose the flip side of that is that these new ways of communicating with patients for some groups of patients can be quite popular. I know I was speaking to a child psychiatrist recently who said that they thought the communication had actually improved because patients were less inhibited if they could speak from the privacy of their own homes rather than having to attend clinics. But I don't know if my colleagues, Tracy particularly, whether you've seen increased complaints or any claims coming through because of telemedicine?
Thank you, Rob. I haven't actually seen an increase in complaints and things. What I would flag out really is, and I've been asked about issues relating how better to manage using teleconsultations. And also I anticipate in future there could be potential issues in view of the pandemic and in view of the urgency and limited maybe resources or time available because of the need for immediate medical advice or quick treatment. What I think would be useful really, and the guidance provided by the Medical Council has been given in timely manner, and it has, as I say, raised the issues which I really like to point out and being asked a lot about, the need to actually treat a teleconsultation, whether that's by video conference or by telephone as such, for the doctor to exercise the clinical judgment, the suitability of that, the need to also, it doesn't compromise the your duties under the professional code of conduct, and for future reference, if things could go wrong in future, I always play devil's advocate in case things go wrong, document that, maintain those records, also ensure, you know, the privacy concerns of patients, the fact that the need to take consent on when you're obtaining personal data of patients. That's a big concern in Hong Kong, and also with the growth of legislation, personal data privacy ordinance and concerns that when you've got concerns for one particular purpose of collecting personal data of a patient, when you're sharing, and it's very important now when things are electronic means, that you get also the patient consent. They're not surprised when, as a private doctor, your information even is shared with the public sector or vice versa in the channels available in the e-medical record system. So take due care and have a look at that guidance. Kim set that out in the chat box. Thank you.
Maybe a question for you, TK. So we've got Dr. Lee, who commented with much praise, talking about active listening being the best counseling and helps resolve patients' problems and conflicts. However, he said that the healthcare management are quite obsessed with statistics rather than the quality of consultation. This does not really help when it comes to managing medical legal incidences. So with your views, how would you change the culture in healthcare management? The frontline professionals really can't practice what they've been taught, you know, when it comes to communication, resolving conflict.
Thank you, Kim, for giving me a tough one. Right. I would say in this way, I think that's Professor Albert Lee. Anyway, Mr. Lee. I would say, number one, all the management people, not only in the medical sector, any sector. I mean, same for organizations providing mediation services. They would have to look at statistics, figures, in order to get funding, right? So from the question, I can read into some sort of confirmation bias, right? Of course, that may be right, that may be otherwise. My sharing is this: how to change the culture. Of course, I'm not an expert in this area, but my sharing is that how to change the culture is the people, each person has got a gauging machine inside our body. So if you are able to do well, say for example, for me, I do mediation for other organizations, but I also practice as a sole mediation practitioners. So my sharing is with a good heart, genuinely care about the parties, right? Then people will say, why this person is doing okay, quite well. And then you share your values with the persons. Then you can gradually change the culture. Just like religious issues. If you say to another person, I'm a Christian, I'm a Buddhist, I'm a Taoist, it doesn't help in any way. But if you behave in such a way, people will ask why he is so positive most of the time, why he is so different from the others. Then you share the values. That's the best I can say. Is to change the culture is to have a group of practitioners sharing the same value. Then you work together, notwithstanding the rules and regulations, notwithstanding the administration people. Then one day, the younger ones, the students, the young practitioners, they will look up to you, and then your values can be spread, and the culture could be built up gradually.
Thank you,
best I
TK.
can say.
Great. Moving on to maybe a couple more questions, because I know we've just gone over time, but these are quite good questions. Maybe for Rob and Tracy, what to do in terms of notification to the indemnity provider when a medical practitioner receives a complaint or a formal claim by a patient? Any quick words with that?
Sure. I mean, I think, well, Tracy obviously is very experienced in supporting members in Hong Kong. Certainly to MPS, the reason we exist is to support our membership. And we're very keen to speak to people early if there's been an adverse event, and if you're anxious that, excuse me, if you're anxious that something may come of it, either a complaint or a claim, it's often better to talk it through, gather your thoughts. And as I was saying earlier, these can often be complicated, and if there are missing bits of the story, better to think about them and sort that out early on, so that any communication you give by way of responding to a complaint, speaking to a family, or any other circumstance, is that there's clarity as far as possible with them. So we certainly pride ourselves in the service we provide, being able to speak to people, because it is an upsetting and distressing time, and just to work through those is why we're here.
Okay, how about the next one for you, Tracy? When audio is available or recordings are available and they've proven to be useful with or without a patient's consent in managing medical legal disputes, have you seen any scenarios like that? Tracy? Oh, okay, we've just lost Tracy, that's fine. Here's another question, maybe for TK. When does mediation become important and useful in medical legal disputes?
I would say in this way, Kim, thank you for the question. Mediation is important all the way because mediation is assisted negotiation. So for the dispute, of course, nowadays, it is right. It is absolutely right under the system to seek legal advice. Then you have the lawyers involved. Then it is perfectly correct. And we all know that our system is adversarial. Adversarial system may result in polarization. So mediation is the jigsaw piece to assist the parties if they want to have an alternative rather than litigation. Then they can engage in negotiation. But engage in negotiation, I can tell you, even pick the right date, the right venue to negotiate. That involves a lot of knowledge and art. So mediation, if the parties are lucky enough to find somebody with some experience, then the person who is able to connect with both parties with different cases, different expectation, different way of communication, then he or she can connect them together, right? And sometimes with a bit of charisma, then they don't want to upset the poor, good value mediator, then they will keep talking, be engaged. And then with some luck, some miracle may come out. So my answer to that question is that at any stage, I will encourage the parties to attend mediation, but I will not push them. And for the lawyers, they know since the 2nd day of April of 2009, under our civil justice reform, one of the underlying objectives is to promote settlement. So the court has done a lot of good work in this respect. So anytime, mediation is important for medical legal disputes.
Thank you, TK.
Thank you, Kim.
Sorry, we had lost you for a little while, Tracy, but what I'll do is I'll repeat the question, quite related because it's about recordings. When have recordings...
Yes, so timely.
When have recordings proven to be useful with or without a patient's consent in managing medical legal disputes?
Yeah, so it's a very good question, often asked that, and timely also of the answers to an inquiry made to the medical council. You know, doctors, important point to remember that doctor must, according to the guidance, obtain the patient's prior consent before doing any recordings. So make it clear to them. It's also a matter of courtesy, really, and also obtain that consent, you know, prior to recording. And also I suggest in some of the cases I've involved with, having that collection of data, that knowledge conveyed to the patient early on, especially at their first consultation, establishing that relationship, introducing yourself, the policy of, especially now with teleconsulting, with audio, video recording, explain the purpose for which the recording is made, future reference. There might be a physical examination by video conference, needed to have reference to it later. It could be limited time in relation to that consultation with the urgency of treatment needed. So my advice really is to obtain the verbal consent, at least by the doctor. Always record that down. Documentation. I always say to my clients. Ultimate test and also further guidance in the question answer about whether that can be admitted as evidence, as people are concerned about that when their patients secretly record. They use that in a complaint to substantiate a complaint against a doctor. Medical counsel further guidance. Ultimate test of evidence is relevance. Is it relevant? They have stated that they're not concerned about how it was obtained in the first place. It may still be admissible evidence in disciplinary proceedings. PIC will also look at that. So I think for doctors, take a care, make sure you obtain that consent, document it for future reference.
Thank you, Tracy. We might be able to squeeze 2 more in, and because this is quite relevant, and I've got requests to maybe extend this webinar. I think this is more relevant to Rob. From your observation, is the duty of candor working in a way it was designed to be working? And is the apology ordinance working as intended in Hong Kong so far as well?
Thanks. I mean, I think both of these pieces of legislation are well intentioned. I think they haven't had perhaps the degree of influence that perhaps the legislators who introduced them had hoped. I mean, the fact of the matter is as professionals, doctors have an obligation where things have gone wrong to be open and honest with patients. And as I say, I think the reasons why that perception that doesn't occur is perhaps more complicated, simply because people are afraid of saying sorry. And equally, I mean, again, be interested in Tracy's comments on this, whether or not someone has a claim will turn on the facts of the matter, not just what someone has said. So, rather silly example, but if you chop off the wrong leg of a patient, whether you've said sorry or not doesn't really affect the fact that the patient has got a good claim against you. And certainly in my experience, but get interested in Tracy's, but rarely did cases turn on the fact that a doctor had simply said sorry. I think working out liability and whether a claim is meritorious or not goes beyond that. But the sentiment is good. What we've seen in some countries with the duty of candor has come in is that the success of that turns a lot on the amount of effort that's put into trained staff and support staff. And indeed, where it has worked is in organizations where senior management support it and actually live that culture and drive that cultural change. In other places, if it simply becomes a box ticking exercise, really little changes. So the message we give to people is if you are going to introduce this, you must put in adequate resources and money and time to educate and support the staff.
Did you want to add some comments to that, Tracy?
Yes, actually, I echo and share and agree with many of those views raised by Rob. No, we don't have a specific duty of candor in Hong Kong where things go wrong. I think the change in the culture, changing the mindset really of individuals I've worked with, and there have been real cases where things have gone obviously wrong, left or right side of the lung or heart, and in those cases often I think it goes beyond just looking at the law. The doctor's made an apology, admitted what's gone wrong. Patient actually will say, okay, what do we do now? Then we fix it. Then we go through the operation. They can enter into appropriate arrangements for that. The priority there was the doctor show was honest, was open, and priority there was to fix the problem, what went wrong, undergo the surgery in the right organ. And to be honest, very few, I was in the background advising, but okay, a claim discharge form had to be drafted, but in any event, it wasn't really needed, and the patient-doctor relationship continued. It was a trusted relationship. There was slight upset, but continued. I was informed the family continued to see this particular doctor. So that early admission in those sorts of cases, definitely important, but it's a change in the mindset and ways of dealing with it and working together, whether that's the main issue, I think, with mediation to drive is the facilitative model. I think TK would agree with me, facilitating in terms of medically and also in handling the aftermath of an unfortunate incident. Thank you.
Thank you, Tracy.
Back to you, Kim.
And TK, you've been very generous in answering a question online. So which party or authority could raise the option of mediation as opposed to complaints being dealt with by the Hong Kong Medical Council? So maybe if I get you to read your answer that you've kindly typed out.
Okay, thank you, Kim. Thank you for the question. In mediation, any party may generate options. I love to do mediation with the presence of lawyers because with the presence of lawyers, the lawyers will be safeguarding the interests of the parties. Then I can say a little bit more of my sharing, or how I did other mediations. But of course, if some mediators, they are very pure facilitative model mediators, they are reluctant to come up with options, then they will use their questioning skills to nudge the parties. And the difference between mediation and handling complaint is this. The focus, the goal of mediation is to achieve a settlement and also to facilitate mutual understanding. So on the part of facilitating mutual understanding, mediation is similar to complaint handling. I would like to say a little bit more. A lot of people are very afraid of complaints. They think that, complaints, so the person making the complaint must want something, either money, upgrade me to the presidential suite, get rid of the 10% service charge, or a night's free of charge fruit platter, right? But in fact, it may not be that case. We have to appreciate the complainant in the sense that, number one, they go along the rules. That means they are still within the regime of telling you what he or she thinks. That's very important. One must respect the complainant in the sense that the complaint is through the proper channel, right? Number two is that, upgrading to the presidential suite or getting a 10% service charge off, that's confirmation bias once again. If we handle complaint, and likewise for handling mediation, we must go back to the very original heart. These people, we must assume that they are not faking. They have their case. With that genuine heart, only when you have that heart, you are able to listen. And the miracle comes. Because you listen, you are able to connect with the parties, right? And then when you say things, right, or you make any passing comments, you have a lot of weight on them, bigger than what you could expect. Then the miracle will come. But then if you have all sorts of skill, questioning skill, summarizing skills, but the parties do not see you as a person who is eager to assist them, i.e. a person with passion. If they don't see that you have passion, then the mediation may fail, even though the mediator or the person handling the complaint has got a lot of skills. And that sounds a bit philosophical, but clinically, I can tell you, that's my experience, right?
Thank you, TK. Thank you for these final words. Could I get some final words from you, Rob, and then from Tracy?
Thanks. Really interesting session. I think a lot of work going on into this complicated area, but the skills, I think, to improve communication and to understanding, to try to both resolve problems early when they've happened and to learn from them constructively, I think could really improve patient care, improve patient experience, and hopefully make the profession, I think, happier and more content, and actually be able to cope with some of these stresses more constructively in the future. So I think conversations like this are extremely helpful in pushing some of these ideas and this cultural change we've talked about forward.
And Tracy?
I think really to share, thank you for your questions and experiences. And in times of challenges and adversity, sometimes it's good to continue these conversations, these dialogues. Maybe this will prompt a change in mindset, the need for sometimes different approach, stepping back. And I'd like for people to emphasize that shift from positions. Often we become very positional in terms of disputes. Look at the interests, both of the healthcare provider, also of the patient and their needs, what they want, the interest. I think if we focus on that rather than standing positional, it's very difficult, and that's where you end up with the formal complaints and litigation. And it doesn't end there, it goes on for years, and it can prolong and it can get worse. The emotions, the stress. So for now, I think skills that we brought up, these terms, facilitation, listening, communication, how to effectively communicate, understand, and also just closing words for those in the medical profession, those in training, take good care of yourself. Of everyone, I hope everyone stays healthy, we continue to learn together and share. Thank you.
Thank you. Could I thank all colleagues for sharing insightful and crucial information tonight. The University of Law is looking to provide more important webinars to support professionals and to help them on their professional journey. Participants are welcome to contact any one of our colleagues here, either the MPS, TK in his mastery, and of course TMed that Tracy represents. So, and could I also welcome you to contact the University of Law if individuals wish to further skill themselves with education, such as the LLM in medical law and ethics. On that note, I bid you good night and thank you very much.
Good night, everyone.
Right. Good night, everyone.
you.
Goodbye.
Thanks.
Thank you.
Bye.
Bye-bye. Good health.